We are following some breaking news for you this afternoon. The Supreme Court has declined to fast-track a landmark case over whether former President Trump is immune from prosecution for charges stemming from his alleged attempts to overturn the 2020 presidential election. The nation's highest court refused the request of special counsel Jack Smith to decide just on that question of presidential immunity. Instead, it will let an appeals court consider the dispute. Special counsel Jack Smith charged former President Trump with 4 criminal counts back in August. The former president pleaded not guilty to all charges. CBS News legal contributor and Loyola Law School professor Jessica Levinson joins us now from Los Angeles. Jessica, let's just pause for a second and remind our viewers why Jack Smith, the special counsel, wanted the Supreme Court just to weigh in on this question of presidential immunity.
It's exactly the right question to ask. Why are we here? And Jack Smith wanted to go straight to the Supreme Court because there is a March trial date in this case. This is the federal criminal case pending against the former president dealing with election interference. Trump has said, all of my charges must be dismissed. This case must stop because I am completely immune. These acts were based on acts I undertook when I was president. We actually don't have a Supreme Court ruling on this, which is not surprising because we've never had a former president engaged in this alleged behavior before. Jack Smith, looking at the election calendar and looking at the trial calendar, said, I don't want to wait for the appeals court. Even though the trial court ruled there isn't presidential immunity and we can move forward, I want to go straight to the Supreme Court. Today, the Supreme Court said, not so fast. Go back to the intermediate appellate court. There's a hearing in that case on January 9th, and essentially the Supreme Court will wait.
And when you're talking about the calendar, that case against the former president is set to begin in early March. That question of presidential immunity, as you say, Jessica, underpins the Trump legal team's defenses. They say that these were all official acts. As president, he has immunity on this. And you also brought up one other point that we don't actually have an answer that's very clear about whether or not, about how expansive that umbrella of presidential immunity is. But we do have that question having come into legal circles back in Watergate. Explain for us what the courts decided in that case and how United States versus Nixon actually may have some relevance into this question of presidential immunity.
Absolutely. Well, we don't have an answer. It's only because we've never been here before, not because, in my view, this is really a difficult legal question. You pointed us back to exactly the correct precedent. It was a case involving former President Nixon during the Watergate scandal. There was a grand jury. The grand jury issued subpoenas in the criminal investigation. They wanted to obtain White House tapes that were made by President Nixon in the Oval Office. He said, no, executive immunity. The Supreme Court said there is a thing called executive immunity. You do enjoy some privileges, meaning you don't have to turn over all information all the time, but it doesn't apply here. It's important for the public to have resolution when it comes to these criminal investigations. It's important for prosecutors to be able to move forward when it comes to these investigations. So in my view, that case points us very clearly towards the idea that there cannot be absolute immunity for criminal acts. Underpinning all of this, the idea that even though presidents do enjoy certain immunities, at bottom, no person is above the law.
And that is certainly something that the Supreme Court has found. At that time, Chief Justice Marshall saying specifically that no president is above the Constitution, that there is not an absolute unqualified presidential privilege of immunity. I want to read what the Trump legal team had to say in their arguments to the Supreme Court, because they didn't want the Supreme Court to rule on this question of presidential immunity right now. For them, this is a win. They said in 234 years of American history, no president ever faced criminal prosecution for his official acts. Until 19 days ago, no court had ever addressed whether immunity from such prosecution exists. They go on to say that this question stands among the most complex, intricate, and momentous issues that this court will be called on to decide, but argue that because of that, there should be no fast tracking, that it should make its way through the normal process. It seems to me, Jessica, that For this legal question, the official acts is going to be something that the judges who are called upon to weigh in on this will need to take very seriously. That question of whether or not this was part of President Trump's purview as president.
Yes, a couple of things there. One, this argument of we've never been here before, I'm not sure that's doing as much work for Trump as he thinks he is, in the sense that it reminds people that we've never had a former president allegedly engage in this behavior while he was president. So I'm not sure if you make that argument to a jury, it would help that much. Second, you're exactly right. We're zeroing in on this question of official acts versus personal acts. And this actually points us to the other big precedential case. And that's another case involving former President Nixon. And it actually was a civil case. And in that case, he fired somebody who was an Air Force contractor, essentially. And it was clear that he fired the person. He took responsibility. The person basically sued Nixon for unlawful termination. And what the court found is that based on official acts taken while president, there is absolute immunity for civil cases when we're talking about damages. This is different, obviously. We're talking about a criminal case. But what we saw the lower court judge rule in this case involving Trump is that there is a difference between candidate Trump and President Trump. And Judge Chutkan concluded that when these statements were made, the statements at issue in this election interference case, that Trump was not acting as the chief executive, not official acts, but that he was in fact acting as candidate Trump. And so there is, and I know this is going to sound really nuanced, but there is a potential that the Court of Appeals or the Supreme Court could say, no absolute immunity, and now go back to trial and argue out the question of which statements were official acts, if any, and which were not.
Jessica, it seems to me, and this is just a quick question, but it seems to me that ultimately this question needs to be decided by the Supreme Court. Why did they decline to fast track this question?
So in part, no decision is a decision, right? It means that they will not acquiesce to Jack Smith's request that they need to fast track that. They didn't give us reasons, and we can think of both legal and non-legal reasons why they might not want to jump into the fray. But one thing that's important to remember is even though a case might scream out for Supreme Court review, it's not unheard of for them to say, let's let this play out in the Court of Appeals first. That's typical. It is very rare for a case to leapfrog from the trial court to the Supreme Court. And because there is that oral arguments date, again, I believe it's January 9th, the Supreme Court can still act quickly if it is able to, if the Court of Appeals makes a decision that they can then take up quite quickly.
All right. CBS News Justice Department reporter Rob Legare is going to join this conversation. He's on the phone for us. Rob, this was something that the Trump administration, or that the Trump legal team has been trying very hard to do, continuing to file appeals, not wanting to fast track, trying to delay. How are they receiving this, and how does it fit into their overall legal strategy?
Right. Well, we haven't heard yet from the legal team. The special counsel's office declines to comment on this, but this fits into the legal strategy of keeping the process in the lower court before it gets to the Supreme Court. It might delay things immediately, but looking forward, thinking about how this moves forward in the Supreme, if it moves forward in the Supreme Court, the appeals court has already agreed, a 3-judge panel that consists of an appointee of George H.W. Bush and then 2 appointees of President Biden. They have already said that they will hear this on an expedited basis. So they've moved this forward, as Jessica rightly mentioned. This is already happening with an argument on January 9th, and so all of their briefs have to be filed before then, and they could rule quickly. They've already said that they intend to hear this and consider this quickly. And so while this does not immediately go to the Supreme Court, and it does immediately amount to some level of further delay for the Trump legal team, it's unclear what this means for the trial date and Smith's case against Trump down the line. Because right now the trial date is still set for March. Right now things have been paused and the proceedings have been stayed as this question is considered. But for right now, this is a win for the legal team.
Rob, you've been following not just the special counsel case related to January 6th and the efforts to overturn the 2020 election, but also some of the other legal troubles that the former president has found himself in. Does this decision by the Supreme Court portend anything for any of the other legal challenges that the former president is facing?
So this is the only immediate question that's before the Supreme Court. But if you look at Jack Smith's other case against Trump in Florida, that federal judge in Florida has signaled that the calendar in this election interference, alleged election interference case, is tied to the classified documents case where the former president is alleged to have held on to national defense information and alleged to have obstructed that investigation. The judge there has said, we're going to see how things play out in the 2020 election-related case before we go to trial here. A hearing in that case is set just a few days before March 4th. I believe, I have to check myself, but I believe it's March 1st. So, and they'll decide when that trial goes forward. And so, any type of changes in the calendar in this D.C. case will likely affect things down the line.
All right, a lot to process. Some major breaking news from the Supreme Court today, deciding not to fast track this question of presidential immunity that Jack Smith, a special counsel, had put forward. Robert Legare, Jessica Levinson, thank you both.